Hello and welcome back to the Prima.Law podcast. I'm your host, attorney James Betzold, and we have an exciting show for you today. We have a brand new lawsuit that's been filed in the Southern District of Texas against Francis Christine Meneses and Julio Carlos Meneses. That is the attorney and owner and the vice president of Meneses.Law. That is Meneses.Law, PLLC. That is the law firm in Houston, Texas, with allegations of some pretty astounding immigration fraud that's been going on, according to the allegations in this complaint, and has affected a number of individuals. So, I have with us today a very special guest, the author and filer of that complaint, attorney Robert Anthony Alvarez from Avanti Law Group in Grand Rapids, Michigan, and he's joining us here today. We're going to do this with very limited commercial interruption. We're going to just briefly mention that if you are an immigration attorney and you need excellent software for managing your case flow, for AI case review, for package assembly, automated forms, and smart interviews, find a free trial of Prima.Law at www.Prima.Law. Now, let's get to this amazing interview. All right, here we are, and today we are joined by Robert Anthony Alvarez of Avanti Law Group, who has just filed a new complaint against Meneses.Law, against Francis Christine Meneses, and some other individuals that we'll get into as well. Robert, welcome to the podcast.
Glad to be here. There's a lot to talk about. There's a lot going on, and there's a lot coming. So I'm excited to be here. I'm excited to be talking about this. It's something that I think the community at large needs to know more about, and I fear that they're going to know more about it, and not necessarily from us.
They're going to know more about it, and not necessarily from us. What does that mean?
That this is a Pandora's box that has been a long time coming, not just in the immigration community, but also I think eventually the government, law enforcement is going to have to get involved because of how serious these things have become in the United States.
Yeah, I mean, the topic of immigration fraud has been around for a long time. I mean, as soon as I started practicing law, we saw it, first and second hand. You can, just in doing old case reviews and stuff, or just what clients will say, right? Clients will say, oh, my attorney said everything's fine. I should just go to the interview, at the consulate. And even though I entered 5 different times, they won't know. So I'll just tell them I only entered once and then I'll be good. Of course, that's a very glaringly obvious immigration fraud, but it's also very easy to get caught for that. And maybe that used to work when they didn't have computers or databases. Yep. But I think a lot of people learned that just doesn't work.
Yeah, especially nowadays with AI. I mean, the government is using AI to peruse all public records everywhere. And they're able to say, okay, well, but you were caught speeding, or you filed a small claims case in this state when you claim you weren't here yet. Right? Or you have a child support case pending, or you're listed on a birth certificate somewhere. I mean, there's so much out there nowadays that it's not like it used to be. And I think we've seen now in these last 6 months, the many changes that this administration has made to try and combat fraud across the board, but also in immigration. So,
yeah, I mean, it used to be people had a fighting chance of getting away with stuff, right? At an interview or something. But then it wasn't long, and they would I don't even know if they were using AI, but if you think of an immigration petition, it can be hundreds and hundreds of pages long, right? And I've been in USCIS interviews where the officer's there, and you can tell that they're not happy. They don't like their job. And you just happen to be there on a case where there's like a stack of papers like that, and another one behind them for the particular case. And to cross-check everything manually, I mean, not easy to do. But like you said, with AI, with computers, not only can they look at internal consistency, but let's go check the rest of the records that exist and see if you're telling us the truth or not.
Yeah, and with previous administrations, I think, had memorandums of understanding that there wouldn't be any cross I don't want to say pollination, but cross information sharing across the agencies, and now they are. So if you ever applied, for example, an ITIN, we just had an individual who had applied for an ITIN, forgot about that, and that's going to show up on the records. And so you're claiming that you weren't here during a period of time, and now there is a record that shows that you applied while in the United States for an ITIN.
And that means they were lying.
Yeah.
And that means what are the consequences, right? I guess we can review that just briefly before we get going, because this is a complaint that alleges serious immigration fraud against, not against an immigrant, but against a couple of corporate entities and a handful of professionals who work in the immigration space. So what are some of the, and usually it's the clients, usually it's the immigrants who are the ones who suffer in these situations. They're the ones who feel the brunt of the consequences, usually because they're so immediate, right? If you're caught lying to immigration, they can deport you from the United States, right? That's an immediate consequence. And I think a lot of attorneys from before my era and before your era took the attitude of, well, we can just do whatever because if something goes wrong, they're just going to get deported. And what are they going to do? Sue me from Mexico?
Yeah, unfortunately, that definitely is the tone and attitude of some immigration attorneys who have less scruples. But it's not going to be as easy anymore. And in terms of consequences, I think we should definitely let everybody know that those consequences for the immigrant, for these individuals for whom we're going to be filing these lawsuits for, those are still very real consequences. They are still facing deportation. They are still facing potential criminal charges, federal criminal charges for lying and falsifying documents and false certifications to obtain a benefit. And we'll talk about that in a little bit as well. But the consequences are prison and a fine. I believe it's a 15-year prison term and a $250,000 fine. So these are very real consequences that these individuals are facing, our clients, who, had they known, right, that this was a possibility, had they known that these statements were going to be put into a record that was going to be submitted to the federal government, they tell us they definitely would not have wanted to risk themselves, especially because they had another path to fix their papers, so to speak. They had another way to adjust their status and get their green cards, and they didn't have to choose. They didn't have to go down this road, but they were talked into it, and here they are.
Yeah. So I think it's already making waves in social media, and I even found a Reddit where they were talking about this case already, and it's only been filed a couple days. Yeah. So it is making waves, and so I think it's worth going over. It's a highly relevant news story to cover, and we got a primary source here sitting right in front of us.
Yeah.
So I can actually pull it up right here. I have a copy of the complaint. So as you can see, Ana Yemi Martinez Garcia is the plaintiff.
And just for everybody's edification, she has given us permission to talk about this. She is very adamant that she wants to make sure that the community at large knows about this type of issue and is well informed going into it, and that can possibly, hopefully, change some lives by helping them avoid these kind of problems or these kinds of issues, or at least being aware of it so they can try and do something about it now.
Okay, so Ana Yemi Martinez Garcia, we have as the plaintiff. We'll talk about what she is. And it looks like there's a handful of defendants in this case. So why don't you walk us through each of those defendants and just explain why are they included in the complaint? Who are they? And what role do they play in this?
Well, we have, to start off, Meneses Enterprises, LLC, a limited liability company in Texas. We're not exactly sure how they are connected to Meneses.Law, but everything that we've found leads us to believe that they are connected in some way. And so they are one of the named parties. We believe that the members of that LLC are Francis Christine Meneses and Julio Carlos Meneses. That's husband and wife. We are also pursuing Meneses.Law PLLC, obviously because they are the firm the entity that is maintaining the corporate status for these attorneys. We also have Rachel Victoria Robertson, who is, I believe, a newer attorney, but she is an attorney. She's a licensed attorney in Texas. And we have Diana Alfonso, who I believe from the documents that we have is simply an individual who was acting as an interpreter for the firm.
Okay. And why name all of them?
Well, Meneses Enterprises and Meneses Law, like I said, I believe that they are the two entities that are involved with providing the entity source for these attorneys to, they're the entity source that is used by Francis and Julio to carry forward their operations. And in terms of Francis, Christine Meneses, she is the principal, she is the member, she is the one that appears in all the videos, and she is the one, from what we've seen so far, that signs many of the G28s and some of the I-360 forms that are submitted. Julio Carlos Meneses, that's her husband. From what we understand, he is the vice president of the firm, and he is there present day to day, handling operations, boots on the ground, so to speak. And he is with Francis making operational decisions that we're aware of that have furthered this operation and this, what we call a scheme. Rachel Victoria Robertson, well, her name appears as the preparer in many of the petitions that we've seen, and she's certified under oath, under penalty of perjury, that she reviewed all of these petitions in every paragraph with the client, that the client authorized all of the submission, including all of the paragraphs in the declaration. And so, according to our clients, that never happened. They don't know who she is. They don't believe they've ever spoken to her. And so we're including her because, well, she furthered the scheme in our allegations in the complaint. And Diana Alfonso, she also signed as the interpreter certification, indicating that she translated all of the paragraphs of the petition itself and the declaration on behalf of our client when they were reviewing and signing these petitions and declarations.
Okay, so why don't you walk us through then, because you've mentioned like you called it a scheme, but it's like their operation, right? What's the operation that's being alleged in the complaint here? How is it that they were operating, and why is it so bad? Like, why does it deserve a complaint in federal district court, I suppose?
Gotcha. Well, two reasons. Number one, the fact that this isn't just a one-off kind of instance. This is something that is systemic. From what we've seen and what we allege in the complaint, this is a system for processing these types of petitions, VAWA petitions specifically, in such a way that they are efficient and maximizes profit and incentivizes high pressure sales. And as we've seen and we allege in the complaint, encourages and or incentivizes falsifying petitions and allegations to ensure that the petition and the declaration meet the very, very high standards that are required for one to qualify and be eligible for a VAWA petition.
So before we go any further, then maybe we should just take a couple minutes, because there may be people watching who maybe they're not immigration attorneys, maybe they don't deal much in immigration at all, and so they might not know what a VAWA application is. It is mentioned in the complaint, so it's worth mentioning here just to maybe give a little bit of a background on that. And I can probably help with that. I mean, a VAWA application, it stands for the Violence Against Women Act, and it's designed to provide an avenue of relief and immigration path for those who are subject to battery or extreme cruelty, either by a U.S. citizen or legal resident spouse, parent, or child, right? And a child, when we say child, it's not really a child who's like a minor, right? It has to be a child who's now 21 years old or older, lives with the immigrant, and is subjecting them at that point in time to battery or
extreme cruelty.
Extreme cruelty, that's it. it's not designed to be for everyone. It's designed for limited cases where there's unequal bargaining power, there's unequal power in the relationship because of a lack of immigration status, right? It's not for everyone. But according to your complaint, it looks like this was one of their main emphasis, or one of the prime candidates for a case that they'd recommend.
Yeah, and so I want to read a little bit from the complaint just to kind of give everybody an idea of what specifically that we're alleging. And so in the introductory paragraph of the complaint, I note in there that that she suffered damages arising from the operation of an ongoing, highly structured enterprise that systematically targets vulnerable immigrant clients and steers them into fraudulent Violence Against Women Act, VAWA, self-petitions they neither sought for nor qualified for. And as the paragraph continues, this enterprise operates through a coordinated network of attorneys and non-attorney staff using standardized high-volume processes to manufacture abuse narratives, obtain client signatures without informed consent, and submit immigration filings to U.S. Citizenship and Immigration Services under penalty of perjury. And remember, we talked about that, those certifications that the attorney, Ms. Robertson, and the interpreter signed. Well, our client had to sign too. Our client had to sign the petition indicating that everything on there was correct, and that it had been read to her. And of course, that certification that she signed was in English. She doesn't read English. She doesn't understand English. And that's one of the reasons why they have an interpreter, because they want to make sure that the interpreter is ensuring that the person who is signing the petition understands what they're signing. And as you'll see in the petition, that definitely didn't happen according to her.
Okay. Well, maybe we should go a little further into the complaint then, because I notice in this, it's still in the introductory paragraph here, plaintiff is one of hundreds, if not thousands of victims of a repeatable and scalable system designed not to evaluate eligibility, but to produce filings that appear to satisfy VAWA criteria, regardless of the underlying facts.
Yeah. Well, and I think now's a good time to talk about what's going to happen at the end. I mean, we'll go through the complaint, but let's talk about what's going to happen once this application, this petition gets processed. Our client is going to have to show up to an interview, especially now under this administration. They are now requiring, last we knew, they are now going to be requiring individuals to show up and to talk to an immigration agent about their petition and about the declaration, and sometimes to offer maybe more evidence or substantiate some of the allegations. And so what's going to happen in this case, for example, when our client, Ms. Martinez-Garcia, has to show up, and if for the first time she hears some of these allegations that they put in there, the look of surprise on her face, the look of surprise on her husband's face, who's going to be there with her,
It's going to say it all.
is not going to end well for her.
Well, and I can tell you, I was meeting with someone today, right? Not going to say who, not going to say what attorney I had to deal with, but what she was telling me is her husband was very upset when she got the FOIA results, because that attorney didn't want to hand over the file. We were able to get it for her. When she read it and she read the declaration and the husband read the declaration, he was pretty upset with her. Like, how dare you say these things about me? That is not true. And her response was, I didn't say those things.
Yeah.
Literally none of them. The only thing that was right here was my date of birth.
And that's something that we're gonna touch on as well. We have a client whose complaint I'm working on right now, as a matter of fact, who during the interview with the creative writers, and we'll talk about those here shortly, with the creative writers, one of the instructions that the intake person, I'm sorry, not the creative writer, with the intake person, that intake person instructed my client to meet somewhere alone without his wife. And he found that kind of suspicious. And obviously she had been through the process herself, and she adjusted status through some other method, but she wanted to be there. And I mean, they're over the phone. So he just told her, yeah, okay, I'm by myself. She was there the entire time. So she heard the entire conversation. He answered all the questions. And then when they finally were able to obtain a copy of their declaration, there were paragraphs in there that both of them said, listen, none of that happened in this conversation. None of that was discussed. None of those facts were ever came out of my client's mouth. And yet there were entire paragraphs dedicated to how abusive financially, psychologically, emotionally, physically my client's wife was with him. And if she had not been there when they had this interview, you can imagine how hurt she would have felt, how betrayed she would have felt, knowing that he was potentially lying to make this stuff up just so that he could get his papers. And that's something that I imagine has been happening or will be happening for quite a number of people who are going to get that surprise when they show up for that interview.
All right, so let's finish up in the introductory paragraph here then. Why don't you take it for us?
All right, so plaintiff sought lawful family-based immigration relief through her United States citizen husband. Defendants instead diverted her into a VAWA-based filing supported by false and unauthorized allegations of abuse, collected substantial legal fees, and then refused to release her client file when she attempted to investigate the submission. So let's zero in on that. Ms. Martinez Garcia is married to a U.S. citizen, and she had a means for applying to adjust her status or do consular processing, at least, either way, to fix her papers. Mm-hmm. And that's what she went there for. She went there to say, hey, I'd like to use the fact that I'm married to a U.S. citizen to fix my papers. I understand that that's a form I-130. How do we get that started? And instead, they steered her into a 360 process. That's important.
See, and to me, that doesn't make any sense. If someone clearly doesn't qualify for a VAWA petition, you don't do it. And if they have a spouse who's willing to petition for them and do the process, you just do the right petition. Now, of course, we would screen for that, but we're not going to push somebody into it if they don't qualify.
Well, but Jim, you understand that the reason why this is so tempting and the reason why it is utilized by not just Meneses Law, but many other firms, is because they use that phrase, arreglar sin salir. And they say, hey, listen.
Which in English means fix your papers without having to leave.
Yeah, leave the country. Because Ms. Martinez Gutierrez would likely have had to leave the country when it came time to her final interview. Mm-hmm. In order to fix her papers, she's going to have to leave the country, request a hardship waiver, and then return legally, right?
Yeah.
Well, with VAWA, you don't have to do that, right? And so that has been a universal theme among these types of law firms that advocate and that sell this type of package and this type of hope to people. Is like, hey, listen, all these other attorneys have told you that you have to leave the country. We're not. We're telling you can stay here and you can fix your papers, and we've got a way to do it. Well, this is the way that they do it, through VAWA.
So it's not some special knowledge. It's not some special program. It's not some special lawyering that's getting done. It's just putting someone into this category instead of what would have been the right one or the ethical one.
Yeah, I mean, Ms. Martinez Garcia and her husband, they went to about half a dozen attorneys before they ended up at Meneses Law door. And all of those attorneys rightfully told them, yeah, listen, the way to do it is consular processing, but you're going to have to leave the country. And then they talked to just one more lawyer or one more law firm, because they didn't talk to a lawyer, one more law firm who says, well, there's another way to do it. Not a lot of attorneys have experience doing this. That's why they don't offer it, but we do. And so
because they don't have experience doing it.
Yeah.
It burns me. Every time I hear it, it burns me. Yeah, I've seen the TikToks of select individuals who are out there making these videos saying, oh, I love to help even other attorneys because they don't know how to do this. Not true. We know what it is. Yeah. We know how to do it in legitimate cases.
It's nothing new. It's been around for years.
Yeah, it's been since the 90s, right? It's exactly. VAWA's been a law since a long time ago.
Yeah.
Um,
And so what they say in their TikTok videos is, well, the reason others tell you that you shouldn't do it is because they don't have experience in it. They don't do it as often, but we do this here all the time. Yeah, you do. But
and you
this is the
shouldn't,
result. Yeah.
because it's not a common thing. It should not be nearly as common as a regular family petition. If you got 1,000 people, and I'm just pulling numbers and examples from my firm, right? If I have 1,000 people coming to my law firm, maybe a handful of them will qualify for VAWA or will qualify for a T visa, right? Maybe not 1,000. If I've got 200 people, though, if I've got 200 people coming to the office, maybe 5% are going to qualify after a screening for it. And less will qualify after the attorney's reviewing it in depth. And we go and see, okay, well, did you ever get deported? Are there any records? Are there any FOIAs we need to pull and find out first? So it's not.
Why is that, Jim? I think we should tell everybody why is it that even after you have looked at that 5%, why is it that you would still narrow it down? Why can't you just file for that 5% who may have initially seemed eligible?
Well, and I think that's probably what some attorneys do. But for me, I don't want to lose my license. I believe in being honest. I know that if I can sleep well at night and I can make my living, I'll be happy. And that's what I want. I want that more than I want a private jet, or I want that more than I want 37 offices across the country, and et cetera.
And also the standard that's used for VAWA, it's extreme cruelty, right? It's supposed to be an extreme remedy, right? It's supposed to be available for those situations where the immigrant is in a position of not having any bargaining power, not having any power to control their lives, maybe in a situation where they can't escape and they have no means because they're completely dependent on this person. Right? And so this was something that was put forth by Congress for those extreme situations. And because it's an extreme situation, it does come with some very good benefits immediately. And what are those benefits?
Yeah, a work permit and deferred action. So protection against deportation. And you can go get a work permit, a social security number. You can start working. You can live an independent life. It serves a great purpose. I mean, don't get me wrong. We filed VAWA cases. Many of them pro bono because poor things are victims and they have no money. And some of them have no friends who can even support them. So, I can give an example. There was a case that we had of an individual who was literally living in a shed in the backyard of their in-laws' house. Their worthless husband refused to work, and any money he got, he would spend it on liquor. And they were living in a shed. It had no insulation. It had no running water. It did have electricity because they ran an extension cord from the house. But it sucked in the winter. So I think cases like that, where there is that extreme cruelty and there is that extreme neglect, and there is that, even in cases where that one also included battery. I mean, those are extreme cases where I think a VAWA is deserved, not my child gives me ugly looks.
My adult child is living here and he's not paying rent. My adult child isn't cleaning his room.
Not enough.
My adult child refused to take out the trash when I told him.
Not enough.
My adult child yelled at me and refused to do anything to help me clean around the house.
I've seen a lot of those cases recently. A lot of those declarations where it's they're giving me ugly looks, and just you said, all these failure to do household chores. Sometimes it says more about, well, we don't need to go blaming people, but it's not enough for VAWA, right? And people will say, well, what's enough for VAWA then? And I'll get, like the lady I was talking to today, I was like, okay, for example, they say, say you have a child who's over 21, right? You can't count anything they did before 21. They're over 21 now. They're still living with you. And they're saying, Mom, you got to give me $200 or I'm going to call ICE on you. Okay. That's a VAWA. Or, constantly berating or putting down their parents because they can't speak English, because, blaming them for stuff, but publicly berating them, physical violence, any sort of thing like that. okay. But if you're saying, oh, you don't pay rent, or they make me feel like, and you can tell if it's a creative writer doing this. Oh, they make me feel inept. They make me feel sad, and they make me feel this way.
And there's got to be more than just that, those instances, right? I mean, it's got to be a situation where the parents can't just evict him, can't just get rid of him, just can't make him leave. It can't just be he makes me feel bad and he's not paying rent and he's not cleaning his room and I don't know what to do. That's unfortunately parenthood, right? I mean, for the reality for many of us, that's just what you have to deal with. But they have a remedy. They could just evict them, and if they can't evict them because they fear for their lives, because they are being controlled, because they are being threatened with calling the police or calling ICE, that's where it crosses the line into VAWA territory.
Yeah.
And that's what I think a lot of people may not fully understand about VAWA, that it's not just your typical everyday, you're dealing with a kid who just doesn't want to get their act together, who wants to live at home forever and have you take care of him. No, it's got to be extreme. And that's a key word.
And I think part of the issue then is, as attorneys, as business people, we have our own businesses. We always want to think about like, okay, how can we be more efficient? How can we bring in more clients? How can we process more cases? How can we squeeze out a few more dollars? Like we're all to some degree a little bit like a Rockefeller, right? Some sort of oil baron, and we want to just, if we can save a few pieces of solder per barrel, we can save $1 million a year, right? Sometimes we look for those efficiencies, and I mean that's all over. I mean, with software you use, staffing systems you use, things like that. We always want to find what's more efficient. What's the difference? Because there's a lot of allegations in this complaint that sort of show how when you take that to an extreme, it can cross the line from operating a legitimate business or an ethical business. It can cross the line into something else.
Jim, I was talking to another attorney. They called me about the complaint and they wanted to just chat a little bit about it. And there were some comments on some Facebook groups about, listen, there's nothing wrong with having a system in place. There's nothing wrong with having paralegals help you fill out the forms. There's nothing wrong with being efficient, like you said, and using AI potentially. You're right, there's not. But this system could have been okay if two things had happened. If the first meeting that the individual had, that Ms. Martinez Garcia had, was actually with a licensed U.S. attorney, right? And if, as in this case, Ms. Robertson, the attorney who signed the petition as preparer, if she had had that conversation and gone paragraph by paragraph with Ms. Martinez Garcia, if at any one of those points an attorney had spoken with Ms. Garcia and gone over the petition or given her legal advice from a licensed attorney, this could have been prevented.
Yeah, I mean, makes total sense. One thing we do in our firm, for example, is, if a client calls and says they want an appointment or something like that, we say, great. The first person they speak to is an intake specialist, someone who's going to just gather name, address, phone number. When did you enter the U.S.? When did you leave? Because we know that getting that information sometimes can take a while, and I don't want that to take up the whole consultation. Yeah. It's personally frustrating for me. But my intake specialist, they can do that, right? So they can gather that information. They don't give advice. And you can be sure that clients ask. They'll be like, all right, so I gave you that info. What do you think about my case? And the answer is, well, the attorney's going to review this. They're going to meet with you, and you're going to come up with a plan and tell you all your options.
That right there. The attorney is going to meet with you. Same at my firm. We have our receptionists take the information, they get all the basic information, and then they schedule the interview. And then I, as the attorney, meet with the person. The first person that they have a contact with that's going to give them legal advice is the attorney. So I do my own TikTok videos too. I do videos on Facebook. I do interviews. And when someone calls my firm, they talk to me. They don't They don't talk to just the intake person. They don't talk to just some salesperson who's getting a bonus for every sale that they make. They're speaking to an attorney. And if I meet with them and I let them know that, yes, you do have this relief and this is what we can do, perfect. After that, then yeah, it goes to my paralegal who starts preparing all the information, all the documents, whatever needs to be done. And then when the package is ready for review, the attorney reviews it.
Exactly.
And the attorney meets with the client and says, okay, listen, my paralegal, this is what they put together. Let's go through it real quick and make sure that everything here is correct.
Right.
Sometimes names are misspelled, dates of birth are off, numbers or whatever. And especially there's a lot of questions on the VAWA petition that you have to ask and that you have to confirm, which is why there is that preparer certification that you have to sign. And then the declaration. If you're going to include a declaration under penalty of perjury, you better believe that I, as the attorney, am going to review that with my client and make sure that everything in there is correct. Sometimes we translate it into Spanish or whatever language so that they have it and they can review it before the meeting and they can bring it with them with changes and suggestions or whatever may have been incorrect. But they need to know what they're signing. And then the other thing, and I think this is also somewhere where this system could have worked, is if at the end, when the documents are submitted to USCIS, give them a copy.
Oh.
Give them a copy.
Oh. No kidding.
Why not give them as an attorney, whenever I file anything, like this lawsuit, for example, before I filed it, I translated it into Spanish, all of it, in 60 pages. 60 pages of legalese. I translated it into Spanish. I sent it to my client. We talked about it. Once she was okay with everything that it said, then she signed a verification and I filed it. And then once it was filed, I sent it to her again. So she has a copy.
Exactly.
Why not provide the client a copy of what they paid you to submit?
In every state, right? In every state, there's an ethical responsibility for attorneys of communication. Right? Maintaining them informed of the status of their case, of the different things in their case. The essential part of what they're getting paid to do is to prepare an immigration application. Not giving them a copy of that, in my opinion, is just the worst thing you could do as an attorney. Not to mention risky. Risky for your license, risky for consequences for yourself and for the client. I mean, that's literally your job. It's your job to give them a copy of the file. They shouldn't have to beg for it. They shouldn't have to come back and ask for it. And we've had clients where we say, okay, we have your copy here. Where do you want us to send it to? And they may say, well, just hold it for me. And we'll say, okay, we're going to send you an email, a copy, so you at least have it in case my office burns down one day.
And it irks me when we've requested files or clients go and request files and the attorneys say, well, this is work product. This is my work product. No, it's not. It belongs to the client.
That's not work product at all.
That's not how it works.
In fact, I dug into this a little bit because when I saw that they were claiming it was work product, I remembered that it's not work product. An immigration petition is not a work product, period. And I couldn't remember exactly what the definition was from the bar exam. So I looked it up. Work product is something that the lawyer prepares in anticipation of litigation, right? So if you're going to go file a civil suit, let's say a divorce for a simple example, or if you're going to file a divorce against the opposing party, and then your client says, and you prepare some memos and maybe you get some information together. And then the client says, actually, I'm going to go with another attorney. And then that attorney's like, hey, there's like a hearing in a week. I need a copy of all that stuff. You'll hand over the client's documents. But if you sat down and drafted a strategy, no, that's yours.
That's work product.
That's work product. An immigration petition is not work product because it's never going to be private. It's always going to go to the government.
Exactly.
It's always going to be subject to FOIA later on. So for these attorneys who think, oh, I'm going to pound out a billion VAWA cases per year, and I'm going to tell everybody that what I'm doing is proprietary and special knowledge, and now it's work product, that's not true.
No.
It's not.
The minute that you can get it from a FOIA, the minute that you submitted it to a government agency, that's no longer work product. And unfortunately, that is the recurring theme among some of the law firms from whom we've requested files, right? Yeah,
and we've seen, and that's actually one of the allegations in the complaint as well, and not just dealing with work product. So you have to wonder, like, I mean, I spotted that one right away. This is not work product. So why would they put it in there? But the other thing they say is, oh, well, it's protected by attorney-client privilege.
Yeah.
It's not the attorney's privilege. The privilege belongs to the client.
Yeah.
So if you're going to tell a client, oh, here's your file, but you can't show it to anyone because it's protected by attorney-client privilege, you're lying. You're straight up lying.
Or when they say you can't talk to someone else about what we talked about because that's covered by attorney-client privilege. No, the attorney, me as an attorney, cannot talk about what I've talked about with my client without her permission.
Yeah, it's
Like,
the
that's why I
benefit
said
for
at
the
beginning of
client.
At the beginning of this video, I say, listen, I talked to her. She said it was okay for me to talk about. Even though this is public record, if my client didn't want me to talk about it, I wouldn't talk about it because it's her story. This is her case. This is her life. This is her claim. That's attorney-client privilege. Anything that I've talked to about with her is private until she says it's not.
And I mean, just talking about attorney-client privilege itself, like, because it's a privilege, well, I guess technically for the attorneys who are listening to this, the privilege is you can't say anything, you can't be forced to testify about it, right? But it's actually, the benefit is really for the client because they're the ones who control it.
Yeah.
They're the ones who can waive it, and they can waive it by going and telling the rest of the world whatever they want. So a client can come into my office, like they often do, and sometimes they'll ask, hey, do you mind if I record this? Because, my dad's going to help me out with this and he couldn't make it to the appointment too. I'll say, okay, go ahead. Or we'll be writing stuff on the dry erase board and we'll have a whole plan mapped out.
And then I take a picture.
And I want to take a picture. Now, sometimes I'm afraid they're going to try and go ask another attorney, hey, can you just do it for me for less? But that's a risk we take, right? That's why we charge a consult fee. That's why we're in the business here. And the idea is if the client is happy with us, they'll choose us. But ultimately, anything that gets talked about, it's up to them to divulge if they want to.
Yeah. I
can't tell them this is attorney-client privilege, therefore you can't say anything about what we say here. That's not how it works. I may not like it. They may, other attorneys may not like that, but that's the way it is, which is why, kind of going back to something we said earlier, you have to, as an attorney, especially in immigration, there's so many people who can rat you out if you're doing something wrong. You can get ratted out by your staff. You can get ratted out by a client who you actually helped. You can get ratted out by whoever. Like, immigration can rat you out. If they think you're committing fraud, they can go to a federal prosecutor and say, hey, go check out Attorney Betzel. We think he's committing fraud. So there's literally no way to be safe while committing fraud against immigration or in the practice of immigration law. It's just a bad idea.
And so I want to talk about a little bit about the fraud in the federal government. So paragraph 44 of the complaint.
Here we go.
So paragraph 44 of the complaint, it says, and I'll read it to you, the federal government has long recognized fraud in immigration filings, including in VAWA self-petitions, as a serious enforcement concern. USCIS's Fraud Detection and National Security Directorate exists in part to identify and refer such fraud, and federal authorities have warned the public against notarial fraud and high-volume immigration filing operations that mass-produce inaccurate or frivolous filings. And as a result, in December of 2025, the federal government issued a policy update in order to combat fraud, given the alarming increase in VAWA self-petitions, which had grown by 360% in a 4-year period.
That's an incredible amount.
360%.
Again, VAWA is not for everyone. So how all of a sudden, is domestic abuse going up 360%? Is extreme cruelty going up 360%? You wouldn't expect to see that. And now I do have to admit, that is an odd number for it to go up by. Do you think somebody maybe rounded up or rounded maybe down to 360?
It's a lot.
That's the name of the form, the I-360.
Yeah, in a 4-year period. That is a lot.
It's an alarming
And people are going to say, because I've had people say, listen, but really, how often is that really happening? How prevalent is it? Well, Jim, you and I had this conversation the other day about this attorney in New York. I can't remember his name, but the attorney in New York in the Bronx, him and his son, I believe, that were convicted of VAWA fraud. They were filing false petitions, fraudulent petitions, and they were convicted. And they got sentenced to many years in prison. And I believe the last article that I read, they were going to have to pay back $15 million in fines and restitution. Now,
wow.
As I understand it, that operation was enormous, and they filed thousands of fraudulent petitions. And so,
a month or total?
Over a period of 2 years, I believe it was.
Thousands?
Yeah.
Okay. I mean, thousands is a lot.
Yeah.
Obviously.
Yep. And they had a system. They had an assembly line in place, and they filed thousands of petitions. Obviously, immigration got wind of it, and they noticed that these attorneys who were attorneys for a while, I think one of them was in his 70s when he got convicted, had been practicing for many, many years and hadn't filed that many petitions up until 2020 when there was a spike in the hundreds of thousands of petitions that they filed, and it caught the eye of the fraud department. And they investigated. They got some clients to provide information, and then they were convicted. And so now, okay, the attorneys have been punished. So what happens with all of those thousands of petitions that they filed that the government now knows many of them were fraudulent?
Yeah.
And that's the question. That's the problem with these types of systems when they're not regulated, when they're not monitored, when they're not created to avoid the fraud that's inherent in creating a system that incentivizes high pressure sales.
Yeah, if you create a system where and here's something somebody told me today, and they heard this firsthand from a lawyer's office. They said, I went there, I said, hey, I don't think I actually qualify for what you're telling me of, when they were referring to a VAWA case. And the person said, don't worry about it. They never ask for actual evidence. We can file a declaration. And they're not going to ask for a police report. They're not going to ask for proof or photos of the abuse or anything like that. They never check, and you don't need evidence. Your declaration's enough. And I mean, that is a system that's going to be subject to abuse. And if you create a system subject to abuse, there's going to be people who are going to be like, I've always wanted my own jet. I've always wanted my own 7 houses. And yeah, I'll do it. I'll take the risk.
Yeah. And so let's look at 46 and 47. A petitioner whose VAWA self-petition contains material misrepresentations may be subject to severe consequences under federal immigration law, including findings of fraud or willful misrepresentation under that specific law, which can result in permanent inadmissibility and denial of immigration benefits. Jim, what does that mean?
That means that this person is never going to be able to get a visa to the United States.
Wow. So not even a tourist visa?
No. There's some exceptions for non-immigrant visas, but to get the waiver you need for that, once you've committed this type of fraud, I can almost guarantee you they're going to say, no, we saw what you did. You don't get to come back.
Yep.
Okay. It'd be very rare. You need to be like an ambassador to be able to come back with that on your record.
And then how do these individuals, for example, speaking of those attorneys in New York that were convicted, how do their ex-clients prove that they weren't in on it?
They don't. It's going to be impossible because they didn't. Right. In immigration, there's something called, at least in regards to a false claim of U.S. citizenship. Right. So someone's crossing the border. They go up to the border and the officer says, wait, are you a U.S. citizen? And they're like, no. Okay. They ask the question, but they didn't know yet. Right? Or maybe they handed them a fake green card or a fake birth certificate. That officer looks at it and says, are you really a U.S. citizen? If they retract right then, there's a chance that they're not going to have that forever bar because it was a timely retraction before they were onto them. Unfortunately, for these people it was New York, right? For the attorney who got busted for this.
Yeah.
they either never read their file, they didn't know. I'm sorry. Immigration is going to look at them and say, there's really no way we can tell. And for the integrity and the strength of the immigration system, this is a national security issue. We're going to just have to assume you were in on it.
Yeah.
Because your signature's all over these forms. You have this declaration which has your information in it.
And that's more so even
More now.
especially under this administration.
Oh, yeah.
So paragraph 47, a false filing can also expose an applicant to denial, fraud, or misrepresentation findings, and, depending on agency enforcement decisions, referral for further enforcement actions such as deportation proceedings and even federal criminal charges, like we talked about earlier.
And that happens.
Yeah.
That, especially under this administration. It used to be you could file a family petition even if you were undocumented in the U.S. If you do that now, they'll send you for an interview, and then they want to put you in immigration court.
Yeah, well, I mean, we've had some colleagues, I think 2 weeks ago, who were mentioning that they received consults from family members of individuals who were already legal permanent residents, who had adjusted their status, who had become legal permanent residents through a VAWA, self-petition, and who were detained at home, at their work, and one individual coming back into the country by ICE and then detained and referred for removal proceedings, revocation of their legal permanent resident status, deportation proceedings, and potentially federal criminal charges as well. And they were already legal permanent residents. I don't know for how long, but they had already completed the process. And so those individuals.
Well, and the thing is, I mean, you can, and I sort of talked about this yesterday to some people. It doesn't matter what status you're finally at. You may have your citizenship already. If you're not born in the United States, assuming you never give up your citizenship or renounce it, if you're not born in the United States or born a natural citizen of the United States, your status is always, for your life, is going to be subject to revocation if they find you got it through fraud.
At any moment.
Any moment.
Yeah. Even U.S. citizens. Right now, isn't this administration going after individuals who are now already naturalized citizens?
They have a special department just for that. And here's an example. I don't know if you remember, I think it was under the first Trump administration, where there was this guy who was like 98 years old. He didn't even know where he was or who he was anymore. But unfortunately, he had been part of the Nazi regime, and so they denaturalized him at that age and deported him to Germany. They can take away whatever you have if you get it through fraud. So, yeah, for those individuals in that other case where they got their stuff through fraud, they're going to be getting, or they probably have gotten, a notice of revocation. And USCIS at any time can say, hey, we did a little digging. You're a liar. You got this through fraud. And so we're taking it all away. And now you can go to immigration court and you have 30 days to whatever. They'll threaten you. You got to leave within 30 days or appeal or whatever. But it's not good news. It's not good news.
All right. Let's skip down to a little bit further in the complaint. Let's go to paragraph 58. We'll talk about the defendant's marketing and sales apparatus. All right. So paragraph 58. This is where we start learning a little bit more about what actually happened and how our clients ended up with this law firm. So paragraph 58, the defendant's operation began with a marketing and sales apparatus targeting Spanish-speaking immigrants. Non-lawyer personnel were presented as licenciadas, a term commonly understood in Latin American countries to mean attorneys. Now, that's important because our client alleges that when she showed up, she met with a person who told her that she was a licenciada. So she assumed it was an attorney. A licenciada is not an attorney. A licenciada is simply someone who has a degree, for example. In Latin American countries, if you have a degree, whether it's an associate's, a bachelor's, whatever, you can call yourself a licenciado or a licenciada. Now, slang, especially in the United States, a lot of clients, they call me licenciado or leak, right, for short. But these individuals that our client says she met with, the person was not a licensed attorney. And that person is who steered her towards the VAWA, the 360, because they weren't allowed to use the term VAWA. So they use the term 360, which is the number of the form that's used to apply for VAWA.
And coincidentally, like 25 other types of cases.
Yeah.
You can use that 360. It's for a petition for an Amerasian, a petition for a R visa, religious workers visa, all sorts of different cases.
Special immigrant and juvenile visas.
Yeah, the SIJS, that's also with the I-360. There's a lot.
And we learned that these licenciadas are essentially sales representatives, and they're paid on an hourly basis, but they're also paid a bonus based on the number of clients that they're able to convince to sign on that dotted line every month. And
there's certain professions where that's okay, right? Like sales, and if you're selling a product. Is that okay in law?
I mean, it shouldn't be. And because this person was not an attorney, I don't think that comes into play, but they are salespeople. That's essentially what they are. And if they have an incentive, they usually, I think a lot of these firms call them, instead of quotas, they call them KPIs, right?
Key performance indicators.
Correct. Yep. And if you don't meet your KPIs, you can be subject to discipline and or termination. And so we learned that these sales representatives, these licenciadas, had to meet around 30 closings of cases, new cases every month. So one a day.
Wow.
Yeah. And they were being paid anywhere from 25 to 35, 40 bucks per case.
I mean, it seems like there's an inherent conflict of interest there when there's a legal responsibility and giving legal advice and incentivizing that, you know, according to the allegations in this complaint, incentivizing the non-licensed practice of law with a bonus.
Yeah.
I mean, it's a recipe for disaster.
Oh boy.
In my opinion.
Well, and let's go down to 64. So 64. Defendant's marketing department produced more than 1,300 videos across various social media platforms. And that's important because that's how, right now with social media the way it is, these videos are everywhere. If you click on one or it comes across and you like it or you interact with it in any way, the algorithm is going to shoot it out to you every time that it can, right?
Over and over and over. Yeah.
Yep. And so you can imagine 1,300 videos, and they're short clips, but they're, I don't want to say high pressure, but they are highly incentivizing clips that basically say, all these other attorneys have told you they can't help you or that you have to leave the country. We can help you and you don't have to leave the country. We're going to help you get your papers. And look at all these people that we're helping getting these work permits. There are videos where the attorney, in this case, Miss Meneses, is dancing along a hallway lined with all of her staff with individuals and their work permits, which is great, right? Congratulations. But Jim, we talked about this earlier. Was it really that difficult to obtain that work permit?
No, that's the easy part.
And why is it so easy?
Because immigration is assuming you're telling the truth and that someone's in danger and they need that freedom from their oppressor or their abusive spouse or child. And the only way to do that most of the time is to give someone the ability to work, pay their own rent somewhere else, have their own money, get their own car, get a driver's license.
Yeah.
That's the easy part.
And so within 6 to 8 months, typically, right, give or take, I don't know how long it is under this administration, but 6 to 8 months, you can get your work permit, right? Even if your affidavit is not enough to pass muster, you're going to get your work permit because it's an emergent situation and Congress recognized that. And so immigration will shoot that out. As soon as they get it, they make sure that you've signed where you're supposed to sign and that it looks like it's complete. They will send you a work permit in 6 to 8 months.
So seeing these videos then, I mean, and I've seen from a number of attorneys do this because I think maybe they don't have enough creative ideas for TikTok videos, but they will go to the post office and get a stack of those white envelopes with the red lines on them. And they'll be like, look at all of these. Look at how good we are. Look how smart. 50 more, 100 more. And they hold a whole stack on the table, whatever.
And they're all work permits.
They're all work permits. Yeah.
Now, there are a few. I have seen a couple of videos where the person actually did get their legal permanent residency. Great.
Great. Good for them.
Hope
it was real.
Obtained by fraud.
Sure.
I hope. that the client obtained a copy of their declaration, they reviewed it, even now having their legal permanent residency, because at any time under this administration, if they review, especially if they decide to come after any of these law firms, they're going to question everybody that went through those doors.
Every single one. They're going to look at all the cases that were applied for in the last X number of years.
Just like they did with those attorneys in New York.
Well, do you remember this? And this comes up once in a while. We actually had this happen recently, and it's probably because of this administration. But you remember the whole issue with midwife births in southern Texas during the 60s or 70s?
Yes.
There was a whole scam going on there where you'd have and they have a list of these people's names, of these midwives who would sign affidavits saying, "Oh yeah, little Roberto, he was born in Texas. I helped give him birth." But they were lies. Yeah, but they were lies. Immigration got wise to it. And now if your birth certificate is based on one of those affidavits from one of those people, what are we now? That was in the 60s and 70s. Now we're in the 2020s. 50 years later, you're petitioning for a spouse and they're questioning your citizenship.
Yep.
It doesn't ever go away. And the thing is, we've seen with the Trump administration now, like, for example, this with everyone's getting an interview for everything, right? And anyone who's not here lawfully, if you file any application and it gets denied, or even if it gets approved, if you're not here lawfully, you're referred to immigration court for removal. Nobody's gotten that tough on immigration in ever. I don't know, since Eisenhower deported a bunch of Japanese people, probably. Yeah. It just hasn't happened. If they go and take the next logical step and say, all right, for these thousands of people, right, for the victims in New York, if they've participated in this fraud, we are going to federally prosecute them. If that happens, then all these people dancing around happy, if they got it through fraud, or if it's suspected of fraud, they may have gotten it innocently, but chose the wrong attorney, and now they're under suspicion, and now they're going to be in federal court trying to defend themselves against a criminal charge.
Yeah.
If they start doing that, no, that's a toxic work permit then.
Now, Jim, let's skip ahead a little bit, because I want to talk about how we filed this lawsuit. And we filed this lawsuit based on what our client has told us, right? And,
well, you filed it, but yeah.
Yeah, I filed it. Sorry. The royal we.
Yes.
Me and my firm.
The holiness.
We filed this lawsuit. Me and my firm filed this lawsuit based on the word of my client. She reviewed everything. She verified that it was correct. We filed it, and here we are, right? Mm-hmm. Now, we are claiming that none of the declaration was not read to her, that the petition was not read to her, that she never spoke to an attorney, right? And so the easiest way to defend against this lawsuit is to produce those recordings. Because we know, if you look at paragraph 69 and paragraph 70, we allege specifically that after retention, non-attorney intake personnel conducted structured interviews, recorded client statements, and transcribed responses into a centralized system. Okay? Paragraph 70, defendants recorded telephone interviews of their clients, including the intake calls used to generate VAWA declarations. Now, if they did, and we believe that they did, then they'll have those. They can produce them. And hey, you know what? We'll dismiss this lawsuit. We'll dismiss it. Produce the tape.
Yeah, well, maybe that would be the wisest thing for them. I'm not their attorney. I'm not going to give them advice. Yeah. But
this is easily solvable. We don't have to go any further. If my client is lying in this lawsuit that we filed, then produce the recordings of those conversations. Produce a conversation between Ms. Robertson and my client where she went paragraph by paragraph, the petition, the declaration, and produce the intake with my client where she makes all of these allegations of abuse that made their way onto the declaration. Produce those right away, and we can be done with this. No need to go any further.
Sounds totally reasonable.
Yeah. Let's pause for a second.
Okay, now, Robert, you mentioned something about creative writers earlier, and that the firm has creative writers. How does that work according to the allegations in your complaint?
All right, yeah. So go to paragraph 71. I've got it pulled up here.
71.
So let me read that to you. The collected information was then transmitted, and this is after the intake. The collected information was then transmitted to a separate department of professional writers. These are individuals, as we understand, they are recruited from colleges, universities, and they typically have a degree in English, writing, whatever that makes them perfect for a job where they're going to be writing all day. And these professional writers who drafted declarations designed to meet internal narrative expectations. What does that mean? Well, that means that they're told, this is how you write, this is what you need to write, this is what we expect from your writing in order to be able to submit this and support the VAWA petition. And the writers fabricated, exaggerated to the point of falsity, or dishonestly recharacterized client statements to align with VAWA eligibility. And what does that mean? That means that if a client made some innocent statement about, my husband every once in a while will yell at me or whatever, they take that and they expand on it and they use some creative license to make it sound worse than it was. Okay. But paragraph 72, direct contact or communication between the clients and the writers, according to our client, never occurred. The drafting of paragraph 73, the drafting of the declaration is based solely on the intake questionnaire created by the non-attorney intake department. And then 74, the collected information was then transmitted to the professional creative writers. And this isn't our quote. This is something from some job postings that we saw where they are looking for creative writing supervisors.
A creative writing supervisor.
Yep.
So they've got a whole department of creative writers. Is that what we're?
That's what we're alleging.
That's what's alleged. Okay.
Who drafted declarations designed to meet those internal narratives, expectations, and then after that, the supporting documents were assembled and combined with automated immigration forms generated through a centralized database, enabling high-volume processing with limited individualized review. Attorneys were involved only at a late stage. Now, let's talk about this. They did not conduct, according to our client, direct client contact or interviews to verify the accuracy of those declarations before they were submitted. And the attorneys who appeared on defendants' USCIS filings, in other words, the I-360 and the G-28, which is the notice of appearance of the attorney, failed to meet or did not meet any established meaningful direct line of communication with the clients. What does that mean? It basically means the attorney who signed that certification saying that she talked to our client didn't talk to our client. At least according to our client, she never talked to Ms. Robertson. And yet there was a certification from her saying that she did.
Whoa, hold up. So who was allowed to talk to the clients according to the allegations? Because you outlined it here. I mean, was it just the initial intake or what?
Yeah, the customer service who takes the initial phone call, and then the intake specialist who then collects the information, uses a questionnaire to ask them questions, right? And that questionnaire is what's used by the creative writer to prepare the declaration creatively. And then the forms are prepared by another department, right? Then all that package, the declaration, the forms, are put together by another department, and then that department sends it to an attorney for review. And as we understand it, at Meneses Law, they have to have 2 attorneys review the package, right, before it gets finalized and sent. Now, the client is called. Typically, we believe it's from the intake specialist who calls them back and says, hey, we need you to sign this so we can send the package out. They're on the phone with them. They send them the email via e-signature and say, okay, click here, click here, click here, click here. That's what our client described to us happened to her. It was a 5 to 10 minute phone call guiding her through the process of signing English documents that were in English, and then they send it off to USCIS. The attorneys, they review the petition and they review the declaration, but they don't talk to the client to confirm it. At least according to our client, she never spoke to an attorney. She never spoke to Ms. Robertson to verify any of that petition or the declaration before it was sent. And so, yeah, there are two attorneys supposedly that review it, but they're reviewing what non-attorneys have already created and drafted for them.
And these attorneys, they're coming in at the end. The determination of who qualifies, that happened by a non-attorney, according to the allegations. Am I understanding that correctly? It actually happens by a non-attorney at the intake interview.
Correct. At the initial interview, with the licenciadas, who are the salespeople, they're the ones who make that determination, who then funnel the person into the next step, and then it goes to the next step and the next step until there's a package that's prepared and sent in.
So, like you said earlier, the whole issue gets solved if you're at least meeting with the attorney at the beginning, or at the end,
or even at the end,
or having some sort of verification.
Yep. And again, this isn't rocket science, everybody. If what our client says is not true, then all they have to do is produce those recordings of having spoken to one of the attorneys, going line by line over the petition, going line by line over the declaration, as is indicated in the certification that was signed by the attorney. In each instance, in each of these cases that we're going to be filing, because this is just one of many, many to come, there is a certification that was signed by the preparer. There's a certification that was signed by the interpreter before it was sent in. And so if any of those actually talked with her and provided her with the advice that, yes, it looks like you qualify and all of these are correct, and she verified it on the phone with them, then our client is lying. And we can get rid of this lawsuit right away.
So you're saying if they want to hand over the phone calls and prove it, if it can be done, right, then there's, as an attorney, there's not much else to do in court, is there?
No, if they produce that, that's pretty much a smoking gun against our client, don't you think? Because we're saying that Ms. Robertson did not go over the petition with her, did not verify each and every one of those paragraphs in that I-360 petition, and did not go paragraph by paragraph as she certified that she did in the declaration.
Yeah, so it's an issue for the interpreter because the interpreter's got to translate all of it. Yeah. It's an issue for the attorney because they have to also go through with the person and they sign that certification. Yeah.
Yeah. So we'll see what happens. We'll see how quickly this gets resolved.
Well, we will. I guess we could talk a little bit because I know there's some allegations about, I don't want to get too far ahead of ourselves. Creative writers. So we talked about the creative writing. Well, that kind of blows my mind. I can understand needing to be able to draft a declaration, but I can say some of the things I've read amongst various attorneys sure end up sounding pretty similar in some of these declarations, right?
And it's going to be easy for USCIS with AI. I think they have an AI now, right?
Yeah.
To be able to compare hundreds, if not thousands,
hundreds of thousands at once
from any one law firm and see just how similar they might be.
Right. And, some things are bound to be similar, but if we're saying, no, it's the same phrase, it's the same template, it's the same factual allegations, I can see where that's going to be an issue.
No matter how creative of a writer you are, you're eventually going
you're going to repeat yourself eventually. There's only so many ways to say my kid looks at me with an evil eye.
Yeah, exactly.
So, okay. So then in the complaint, from what you've laid out already, it sounds like the client never really had a meaningful interaction or meaningful consultation with an actual U.S. licensed attorney. Is that the case?
Yeah. If you go to paragraph 113, we state specifically in there that plaintiff, Ms. Martinez Garcia, never had a meaningful consultation with defendant Meneses, Ms. Christine Meneses, regarding VAWA eligibility, the difference between a family-based petition and a VAWA self-petition, or the legal risks of filing false abuse allegations. She also says Ms. Martinez Garcia also alleges that she never spoke with defendant Meneses in any substantive way about the factual content of the declaration submitted in her name. And she confirms in allegations 115 and 116 that she never spoke with defendant Robertson about her application and that she never spoke with defendant Robertson about her declaration. The communications under paragraph 117, the communications between the plaintiff, Ms. Martinez Garcia, and the law firm were handled by staff. No attorney from defendant Meneses Law reviewed the factual allegations with Ms. Martinez Garcia in Spanish or any other language before filing. So, again, we're back to the same thing. If Ms. Martinez Garcia isn't telling the truth, then it'll be easy to prove. Produce the tape. Produce those conversations, which we know are being recorded.
Well, and it's interesting because I can share, just what I've learned personally about the operations of Meneses Law. Because before they hired an attorney to be the intermediary between me requesting copies of files that clients wanted me to do a second opinion on, right? So they went out, hired an attorney to handle that, and then I no longer communicated directly with anyone there. Before that happened, one of my assistants was having a hard time getting a file. Like, we had a hard time getting all of the files that we've requested. So I got on the phone as well. I called up, and sure enough, about 45 minutes of just waiting before even the first person answered the phone. And then the first thing that the receptionist who answered the phone says is something like, yeah, you're calling us and you agree that you're not allowed to record this phone call. If you record this phone call, it's illegal. And if you do decide to record the phone call, even though we said you can't, if it falls into it could fall into immigration's hands and you could end up getting deported, and this could be used as evidence against you.
Wow.
Yeah, 45 minutes on the phone just to be greeted by that. Not fun. And I mean, so they're telling the clients, they don't want the clients recording the phone call, but you're alleging in the complaint here that that's what they do all day long, or with all the incoming phone calls, or at least with the client phone calls. That's the allegation?
Correct. That's the allegation in the complaint, that they are recording these calls, and that they should have these recorded phone calls if they happened. If one of the attorneys, if Miss Robertson actually spoke with my client and went over the petition with her and went over the declaration and each paragraph, then they have the recorded phone call and they can produce it, and this lawsuit will be over rather quickly.
Okay, well, I think it's important to talk about the difference then between, because there are some cases where, as a lawyer, like especially in a criminal case, that's where it's more clear. There's going to be cases where the case just the facts don't look great. They don't look great in your favor. But if you can advocate strongly enough for your client, if you can make the case, right, that they will say, make your argument, be convincing, maybe get some creative writers to help you write a compelling story about it. Maybe that's a case then that can get approved. But I think in immigration anyway, there's a difference between filing a case that, and clients will ask, they'll say, well, what are my chances? And I always try and steer away from giving a percentage, but usually they insist. But there's cases that are weaker, where there's just less evidence. There's less detail that they can provide in an affidavit. Maybe there's not a police report. Maybe there's not photos of injuries. Maybe there's not a lot of these other things that would make it a strong case. But it still is a case. And the client wants to go forward with it, knowing that it's not the strongest case in the world, but it's the only thing they can do and they're out of options maybe. So maybe then as an attorney, it's the attorney's job to do their best, put the best case forward. But what's the difference between that and, according to the allegations in the complaint, what we saw happening here?
To cut to the quick, the fact that you as the attorney are meeting with the client and discussing the facts, discussing the law, and explaining the pros and cons, and having them make an informed decision. That right there is everything. I mean,
so that's the difference compared to the allegations
Jim,
here.
Would you ever let any client come through intake, through submission of their applications without talking to you?
No way.
If you had an associate, would you let a client come through intake, through submission without at least talking to them?
No, they would have to talk to an attorney who knows what they're doing, who is capable.
And who is a U.S.-based licensed
A
attorney?
U.S.-based licensed attorney.
Yeah, we know that some of these firms are using attorneys from other countries.
Yeah, and I've seen
Colombia, Costa Rica.
I've seen in my practice, where we've come across situations where there's an attorney and they're getting referrals and they're charging U.S. fees, but they're not a U.S. licensed attorney.
Yeah, you see them on TikTok all the time.
Yeah, they're an attorney from, like you said, like Colombia is famous for that. They might be a Mexican attorney, but and it's not to say anything bad about attorneys from other countries, but the education that they get is vastly different than a U.S. Licensed attorney.
Well, even aside from that, where's the accountability? If I hire an attorney from TikTok that I found who is based in Colombia and they mess up on my petition, how do I go after them from the United States?
You don't.
You don't.
There's no practical way.
Yeah. Here, there's the Bar Association, there's federal court, there's state court. You can go after them. You can hold them accountable. But if it's an attorney, even if he's an attorney from another country, good luck. I mean, once they've got your money, there's no way for you to get it back. It's going to be virtually impossible to go after them from the United States for this type of case. Now here, these attorneys are based in the United States. These attorneys are bound by the ethical rules of their state bar, and they're bound by the laws of the United States, and they can be held accountable when they violate those laws and when they violate the rights of their clients.
Yeah, and I mean, I feel bad for the people who end up going with one of these, TikTok foreign attorneys, something like that, because there is no accountability.
Yeah, and
they're just sending money and it's gone.
Yeah, it's funny because you see, like I was watching a TikTok that came across the other day. It was a live, and he says, "I'm not an attorney, and I'm not giving legal advice." And his entire live was giving legal advice and answering questions for people and giving them his number so he can help them fill out some forms.
Yeah.
Wow.
Yeah, no, you definitely want a U.S. based. And I mean, even simpler things like rules on perjury, right? Rules on potential consequences. Like if a client comes to me and says, hey, let's lie to immigration about my multiple entries because I know that's an issue.
And they won't find out.
I can tell them that's a felony, and no, that's a bad idea. So it's good not just for the client, but for the whole system. But again, sort of going back to like the difference between a case that's weak and a case that's based on fraud, right? I know there's attorneys out there who will say, well, I handle a lot of VAWA cases. I'm an expert, and we do this. There's a system of repeated abuse over a period of time, and that has a cumulative effect, which rises to the level, all of those things together, as extreme cruelty, which would qualify the client for VAWA, the benefits under VAWA. Yeah. And I get that. But that's not this case, according to what I'm reading in the allegations. What I'm reading in the allegations is, I told them this, and they changed it and exaggerated it so much that it became false, and they said this. They added, according to the allegations, these things in the declaration
that were not true.
And they never bothered to verify it with the client. Or did I read this right? In the allegations you talked about in this complaint, these departments being isolated from each other.
Yes. So as we understand it, the different departments, even though they're held in the same building, they weren't allowed to interact, and there's cameras everywhere. And so they were kept isolated from each other. And that, I mean, it's kind of curious why that would be. I mean, you would think in an office setting, except when everybody was called to line the hallways so the attorney could dance down the hallway with the client and his work permit. Aside from that, everybody kind of had to keep to their own department.
So then the allegation is that you didn't even have, like, you couldn't do fact checking across departments. That's what it sounds like. Is that?
Yeah, as we understand it, if like the attorney, for example, if the attorney had a question about the petition or the declaration, they would send it to either the paralegal or the intake person for them to follow up and figure it out. The attorney couldn't just pick up the phone, call the client, and just clarify.
Yeah. Well, I think that's one of the biggest issues then that I saw as I was reading the complaint, is because we know there is a difference between, you know, zealously advocating for a client in something where even if it's a weak case, it's not a lie, right? But it doesn't look like that's this case. This case, according to the allegations and what Anna was saying here, no, there's invented stuff. There's stuff where this person didn't qualify, or they even had a better alternative. Better meaning more clearly eligible for, right?
And so for a lot of the immigration attorneys, because I know there's a lot of immigration attorneys who are very worried about how this is going to impact them and that their clients are suddenly going to come after them. Well, listen, as long as you're the one that talks to the client, as long as you're the one that explained the law to them, as long as you're the one who reviewed the packet with them and before it goes in and out, as long as you know that those allegations are true and correct based on your conversation with the client, you've got nothing to worry about.
Yeah.
This isn't a let's go after all the immigration attorneys. No, read the complaint, understand why this has been a problem. And the majority of immigration attorneys across the country, even though they try not to talk about it because they're afraid of getting sued themselves, as has happened before by certain big law firms that like to flex their millions.
Mm-hmm.
This isn't about you, and you know who this is about. And this is about getting some sort of justice for these individuals who allege were taken advantage of and who are now placed in the very precarious position of not just getting deported and being permanently banned from ever being able to adjust, even if they're married to a U.S. citizen, but also facing now potential criminal consequences because of it.
At the very least, removal proceedings, and at the most, yeah. It's just a question of when it happens, in my opinion.
Not if, but when.
Yeah. And so I think, yeah, and it's important. It's understandable that some immigration attorneys are going to be concerned about that because, you know, in the practice of immigration, sometimes, you know, that case gets approved. Sometimes that case doesn't get approved. And you look back and you say, boy, it sure looks like I did everything What you're alleging in this complaint here isn't like somebody had a bad day or somebody made one mistake. What you're alleging is that there's a system that they systematized in operation for high volume, invented facts that resulted in false petitions being signed and filed with the U.S. government. I think that's very different from maybe some of the other attorneys out there who, you know, they freak out when they get a negative review from a client. Right. I've had people come in and do a consult with me, and I honest with them, and I say, I'm sorry, I don't think there is nothing I can do for your case because you're not eligible. And next thing I know, I get a ding on my phone, and it's a negative review. This attorney doesn't care about me. This attorney doesn't
know what he's talking about.
Right, doesn't know what he's talking about, because I saw on TikTok there was an attorney who said it doesn't matter if I entered unlawfully. I can get my papers here.
No matter how many times. And my kid doesn't have to be in the military, and it doesn't matter if I have a removal order. So this attorney, that happens to anybody, right? You look at any business, there's going to be things like that. But that's not what this case is about. That's not the people who come out of the woodwork and say, me too. Yeah, I fell for this too. And I think that's an important distinction. It's not let's go. For any of you immigration attorneys that are concerned that this is going to be a Pandora's box and there's going to be a wave coming after you, no. Read the complaint, understand why this was filed. I understand why the many, many, many more that are coming against not just this law firm, but others, why they're getting fined. Okay? And you have nothing to worry about if you actually talk to your client. This firm created a system, and at least according to the allegations, didn't put in the proper safeguards to ensure that these types of issues wouldn't come up.
Well, I think that's a good place to wrap it up. There's a lot of information. Give us a little bit of background and more context into this complaint that has been filed in federal court against Meneses Law, PLLC, against Francis Christine Meneses, Julio Carlos Meneses, and some of the other defendants here. I want to thank you for your time today. Thanks for joining in here. And we look forward to an update as things move along.
All right. Thank you all. Have a good one.
All right.